Tonight, we begin with a development that immigration attorneys, policy experts, and advocacy groups had anticipated, debated, and prepared for. An announcement that unfolded not over weeks of congressional deliberation, but in a single afternoon. A single afternoon that will reshape the timeline for thousands of families. A single afternoon that will alter the calculus for employers nationwide. A single afternoon that will redefine what's possible for millions waiting in the immigration pipeline. What U.S. Citizenship and Immigration Services did today crossed a line that critics had hoped would hold. And when that line broke, the immigration community did not hesitate. They responded with relief, urgency, and immediate action. For 18 months now, there had been signals, not official announcements, not leaked policy drafts, just signals that USCIS was preparing something unprecedented in scope. USCIS has been understaffed, yes, but they have been methodical in their understaffing. Their moves have followed a certain rhythm, a predictability, almost a bureaucratic ritual. But what set off alarm bells in immigration law firms and advocacy organizations this January was that the rhythm went silent. Immigration attorneys who monitor processing times know the indicators. The monthly visa bulletin updates, the premium processing expansion announcements, the incremental policy clarifications, the sudden freeze in new guidance. All of that went quiet. And whenever USCIS goes quiet, it means something is about to get loud. Early this morning, Department of Homeland Security officials detected what they described as a comprehensive policy framework, including regulatory changes that had not been implemented in over 15 years. These are the kinds of sweeping reforms that USCIS only deploys when they are signaling something very specific: capacity expansion, processing acceleration, or systemic overhaul. Immigration observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that USCIS was changing its operational posture. And when a federal agency shifts operational strategy without explanation, even by modest measures, the immigration community pays attention. The policy announcement issued by USCIS tonight was not normal. It was not routine. It was not symbolic. It was urgent. Senior officials, after closed-door briefings, described USCIS's move as aggressive in scope, immediate in implementation, and perhaps most importantly, retroactive in application with significant relief provisions. But policy announcements only work if applicants understand them. The immigration community did not hesitate. In fact, their response today was among the most coordinated we've seen in modern immigration advocacy. Here's what we know. Within 2 hours of the official release, immigration law firms mobilized response teams. These weren't the standard consultation protocols. These were emergency intake procedures, systems and resources that attorneys only deploy when they are preparing to process thousands of applications simultaneously. Tonight, multiple legal sources confirmed that USCIS launched eligibility expansion on 3 major categories, including employment-based green cards that had recently been backlogged for what analysts believe was capacity limitations. USCIS announced relief before the fiscal year deadline could create processing chaos. They addressed the decades-long EB-2 and EB-3 backlogs. They addressed family-based visa processing delays. They addressed H-1B renewal complications that were likely preparing to affect hundreds of thousands of workers. In other words, USCIS targeted the structural bottlenecks, the processing delays that would have made timely adjudication impossible. This is what made the Department of Homeland Security's announcement so urgent. USCIS's policy change wasn't just symbolic, it was actionable. It represented the kind of reform that could transform immigration timelines if implemented fully. And the agency, understanding that fully, responded with comprehensive guidance, not vaguely, not tentatively, but systematically. They didn't issue general statements about future improvements. They didn't promise incremental changes over years. They announced immediate premium processing expansion for all employment-based categories. They announced automatic work authorization extensions for pending adjustment applications. And here's where the story becomes even more significant. Policy analysts now believe that USCIS's latest move was designed to test the viability of modernized processing after years of mounting criticism. USCIS wanted to see whether the immigration system would support accelerated timelines. But instead, the opposite happened. Immigration attorneys didn't express skepticism. They launched coordinated outreach campaigns that were so swift, so comprehensive, that even USCIS noticed. You don't get USCIS's attention easily, but today, the immigration community did. Immigration policy experts speaking with legal publications under anonymity described USCIS's shift as transformative, a way to address systemic dysfunction. But applicants learned today that they must remain both informed and proactive. The application procedures were not only clarified, they were streamlined so precisely that eligible applicants could begin filing within days. That timing matters because it shows intentional design. It shows that USCIS is not simply managing backlogs, they are eliminating structural barriers. As reports continued coming in throughout the afternoon, we learned more about the scale of USCIS's announcement. Employment-based applicants gained access to concurrent filing procedures, forcing immediate strategy reassessment among corporate immigration departments. Family-based petitioners received clarification on aging-out protection that had been ambiguous in the last 2 years. H-1B workers operating under extension provisions reportedly gained automatic 540-day work authorization used by USCIS to eliminate employment gaps. This wasn't just incremental policy adjustment. This wasn't just administrative convenience. This was systemic capacity expansion. This was procedural revolution. And procedural revolution is the one thing the immigration system has struggled to maintain since comprehensive reform efforts stalled. For every backlog reduction they have announced, processing delays have countered with something that extends timelines elsewhere. Remember, critics thought USCIS would maintain restrictive processing standards. They thought the agency would prioritize enforcement over service delivery. They thought meaningful reform would require congressional action. But tonight, the exact opposite is happening. USCIS is expanding eligibility through regulatory authority. The agency is prioritizing application processing efficiency. Meaningful relief is being implemented through executive discretion. What makes this moment so consequential and so unexpected is that USCIS's latest move happened at a time when the immigration system is under unprecedented strain. Applicants want faster processing times. Employers want workforce stability and visa predictability. Advocacy groups want fair treatment and transparent procedures. Congressional critics want stricter controls and reduced backlogs. USCIS is balancing these demands while managing record application volumes. And when agencies in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from necessity. The Department of Homeland Security's policy guidance, now circulated through official channels, was designed to signal that the administration is not willing to allow indefinite processing delays. Officials said plainly that previous processing timelines were inconsistent with statutory requirements for timely adjudication. That is diplomatic bureaucratic language for, "We've been failing our legal obligations and we're fixing it now." You don't usually hear that tone from federal agencies unless something serious is at stake. Meanwhile, the USCIS director addressed stakeholders in a measured, conciliatory briefing tonight. The director said, "We recognize the human cost of processing delays." The director said, "We are committed to leveraging every available authority to deliver timely decisions." And the director said, "This is just the beginning of a broader modernization effort." These are not rhetorical flourishes. These are statements from an agency that understands just how high the stakes have become. Here's what makes the situation even more significant. USCIS's latest move wasn't isolated, along with the primary policy changes. The State Department also announced visa interview waiver expansions. ICE issued updated guidance on prosecutorial discretion in removal proceedings. CBP increased Trusted Traveler Program capacity targeting border processing efficiency. All of this happened within the same 72-hour period. When multiple immigration agencies move simultaneously, it means something larger is underway. Immigration analysts are now considering several possibilities. One is that USCIS is preparing for comprehensive digitization of the entire application system. Another is that USCIS is attempting to reduce backlogs before the next fiscal year deadline. A third possibility, the one exciting applicants the most, is that USCIS is attempting to establish a new baseline for processing standards across all categories. But today, the agency took uncertainty off the table. They didn't issue vague promises about future improvements. They didn't announce pilot programs with limited scope. They didn't suggest incremental changes pending further review. They implemented immediate binding policy changes with clear timelines. What we're watching now is a test of implementation capacity. USCIS wants to see whether accelerated processing can be sustained. Applicants want to show they can meet filing requirements efficiently. Immigration attorneys want to prevent procedural errors that could delay adjudication. And advocacy groups want to prevent any rollback of these expanded protections. Tonight we've heard from immigration law firms who are now conducting emergency client consultations. They say eligible applicants should prepare documentation immediately. They say premium processing expansion takes effect within 30 days. And they say USCIS's decision to implement automatic work authorization extensions is likely part of a broader efficiency initiative intended to reduce administrative burden. But the immigration community is not complacent. In fact, applicants are mobilizing rapidly. Their response today, organized, thorough, and strategic, sent a message to USCIS that the community is ready to engage constructively. And it sent a message to policymakers that administrative relief generates immediate positive response. As the coming weeks unfold, we expect more details to emerge about what exactly USCIS hoped to achieve with this comprehensive announcement. But what we do know is that the agency's action was timely. It addressed critical processing bottlenecks. It provided immediate relief to thousands of pending applicants. And it established a framework for ongoing system improvements. What happens next will depend on what USCIS does in the next 6 months. If they sustain these processing improvements, this moment will be remembered as a turning point in immigration administration. If they maintain momentum, applicants and attorneys have already shown they are ready to participate fully. They have shown they are ready to respond. And tonight, for the first time in years, the immigration system appears to be moving forward. USCIS headquarters is busy, intensely busy. And when USCIS is this active, it means they are planning comprehensively. It means they are choosing their next reforms carefully. Because tonight, USCIS demonstrated something that many had forgotten. That administrative agencies can act decisively within existing authority, that processing efficiency is achievable with proper resource allocation, and that meaningful immigration relief doesn't always require congressional legislation. This story is far from over. But tonight, one thing is clear. The immigration landscape has shifted. Processing timelines are being compressed. And thousands of families just got a chance at faster resolution. And we will be here, watching every detail as the next phase unfolds.